Hello, thanks everyone for joining us today, and we're going to be talking about the Telephone Consumer Protection Act. In 1991, President George H.W. Bush signed the TCPA, or Telephone Consumer Protection Act, into law to address an increase in fraudulent telemarketing and curb annoying telemarketing calls that always seem to come around dinner time. And more than 20 years later, the law's going strong, but unfortunately, despite the significant evolution in covered technologies, that the same law still governs all sorts of business-to-consumer communications. Unfortunately, this has now led to a cottage industry of plaintiffs' lawyers bringing frivolous lawsuits against companies based on their communications with consumers. And the Supreme Court did recently try to cut back on some of these frivolous suits by clarifying some of the definitions in the TCPA. Yet even with this recent Supreme Court ruling, we're still seeing efforts to undo the progress made in that court case. And particularly as states try to produce their own mini TCPA bills and are doing so in growing numbers. In this episode of Cause for Action, we're going to be taking a deeper dive into what is happening in the states and how they're looking to increase litigation under their own mini state TCPA laws. And today I'm going to be talking with Megan Brown, who previously appeared with us in Cause for Action. And in her previous appearance, she was also talking about the TCPA. And Megan's a partner at the law firm of Wiley LLP, specializes in communications law, including the TCPA. And hello, Megan, and hope you're doing well, and thank you for joining us today. So just wanted to start off our conversation with a quick overview of the TCPA. Why was it created, and why are the states now debating their own versions of the statute?
So, as you alluded to, the TCPA has been around for a while. It's been updated to sometimes try and keep up with technology. But the main goal of it was to strike a balance between sort of limiting the tools that telemarketers can use at certain times and under certain conditions and empowering consumers, but also recognizing that telemarketing is an important aspect of business communications. And so you see in the legislative history and in the statute, it tried to strike that balance by imposing certain conditions on the use of certain kinds of calling technology, and sort of set us down that path. Some people refer to it as a privacy bill, but you mentioned at the outset, it was really about the dinner time calls and trying to sort of address some of those more vexatious telemarketing practices.
So why are the states now trying to get into the mix?
Well, I mean, I think everyone kind of agrees that there's been a big uptick in illegal and unwanted robocalling. That is a common refrain we hear at the federal level and at the state level. And as you alluded, there's been a lot of litigation under the federal TCPA. The Federal Communications Commission regulates and implements that statute, and the Supreme Court, in that recent decision you mentioned, kind of put some guardrails around one of the key definitions. And that, I think, has created some obstacles for litigators who want to bring these class actions. This is a very attractive statute that litigators are using. And as they're encountering obstacles at the federal level, they're going to be looking to state law, many of which have long codified some of the same restrictions. So I think that's where we're going to see that pressure, seeing these statutory damages and these multi-million-dollar judgments. It's too attractive to sort of let it go at the federal level, although I think ILR has done some really good recent work that litigation is not over. That federal litigation continues, but they are looking to the states as a venue where they can pursue these claims.
Okay, but I mean, one of the things I'm always struggling with the TCPA, as we're talking to policymakers, is that they always seem to conflate legitimate communications with consumers versus fraudulent calls, and don't seem to understand that fraudulent calls are already illegal under the Telephone Consumer Protection Act. But the problem seems to be that so many of the fraudsters are effectively judgment proof. Are these state statutes going to fix that problem at all?
Well, I think you're right on that the problem set is being conflated, right? But I think there's actually even more going on. There's illegal scam calls, which are just outright fraud, right? There's legitimate business communications, with which federal law and the First Amendment protects. And then there's also these sort of scam calls, the robocalls and the spoofed calls where you have caller ID being obfuscated, hidden, or distorted. And so I think what we've seen is a kind of a, as you said, the conflation of these buckets of problems. And I think the challenge is, some of the changes we're seeing proposed at the state level don't address the problem that they may think they're solving, right? The problem that may cause their citizens pain is really spoofed calls, caller ID obfuscation. Some of the proposals don't really address that. And I think that's one of the problems I see with this move to expand class actions and go after legitimate businesses for their telemarketing practices.
I mean, how does the litigation work in this space? I mean, is it really just kind of a cash cow for the plaintiff's attorneys? Or do they actually ever end up going after the legitimate bad actors?
I mean, I honestly haven't seen in the research you guys have done and in the cases that the true bad actors are targeted. As an example, right, the Federal Communications Commission and the state of Texas and others last year brought an enormous case with like an over $200 million fine against some bad actors down in Texas who were, pumping out billions of illegal robocalls. They were spoofing caller ID. Those kinds of bad guys aren't the target for the plaintiff's class actions. The plaintiff's class actions, according to the work you guys have done and what I've seen, often are legitimate U.S. companies, sometimes small and medium-sized businesses whose compliance plan fails for whatever reason, or who face an allegation that they made calls without appropriate consent. And that gets into a fact question about the adequacy of consent or whether a consumer revoked consent. And so I think you're seeing a mismatch between the litigation that's been authorized and the bad actors who are really causing the pain out in our economy.
Okay. The states that have done something in the mini TCPA space, not a huge number of states have passed changes recently, but there have been a handful. But do you expect many other states are going to try to go down that route?
I think several might, particularly if some of these newer changes, these innovations, I'll call them, get a toehold. So we've seen things at the state level that would, for example, fundamentally change and expand the approach to technology. So at the federal level, what is regulated is the use of what we call an auto dialer, which it has a few statutory requirements, but basically, it is supposed to have the capabilities to select calls and make calls using a random or sequential number generator. And that generated a lot of litigation. The states that are thinking about innovating in this space are going more broad. And they're saying, and I want to pull up some language that I've jotted down, they're targeting an automated system for the selection or dialing of numbers. And that's a broader approach than the federal TCPA definition. And so I think that's a way that they may seek to expand the litigation options for folks who can't get traction under the TCPA because someone's not using a federal auto dialer. And I think we've seen other things that certain policymakers want to do, which is expand class actions, make it clear that lawyers can get attorney's fees, eliminate the intent requirements. Some state laws currently require a knowing call or a knowing violation of, for example, their do not call laws. And I think all of those things taken together, if we start to see that momentum grow, you will see those laws pop up in other states because the damages are just so attractive. I heard a legislator recently say that if their new law passed, maybe they would switch their specialty from what they did now to TCPA plaintiffs' work because it would be so lucrative with the combination of statutory damages and the class action vehicle.
So, do you think there's a coordinated effort underway by the plaintiff side TCPA bar to try to shop stuff to various states, or is it just kind of hopping? Or, occurring more organically?
I don't know or want to speculate as to how folks are coming to these drafts. I think there's people of goodwill who are genuinely responding to citizens' complaints. And I think they might just not have the right match between problem and solution. And if you don't mind, I think one thing that I wanted to emphasize here that I've seen in some of these discussions is sort of a lack of familiarity with some of the many things that are underway at the federal level that address this problem and that need to be given some time, right? The federal government has juiced up several of the existing laws, including the Truth in Caller ID Act. So a lot of the underlying activity is already a violation of state and federal law. And then there's been a real move over the past, I'd say 2 to 5 years to require the telephone companies to do a lot on their end. Several pieces of legislation have been passed, and there's a whole array of technology solutions that are now being deployed to really get at the authentication of traffic and sort of stop it at its origins. So that's something that I think is important and is often valued at the state level, when I think legislators are trying to relieve some pain that their constituents are feeling. And then also, there is a desire to help the plaintiffs bar sometimes. And this has been a very profitable area for certain lawyers.
I mean, is this an area where the state attorney general community, they could be more active? I mean, just using the tools that they already have, rather than trying to give them new tools, or give the plaintiffs bar new tools? But
I think so. I mean, many states have recently entered into memoranda of understanding with the Federal Communications Commission, and that they were involved. Texas, for example, was involved in the enforcement action I mentioned earlier. I think we've seen folks sign up with the FCC states just in the last couple of weeks. They've been sort of jumping in to try and increase this collaboration to identify the bad guys. I certainly would rather see state AGs work collaboratively with the federal government to go after bad guys rather than deputize the attorneys general. The plaintiffs bar, I think one of the arguments I've seen is that the AGs don't have a lot of resources, and so it would be more efficient to allow the private sector to proceed by private cause of action. And I just don't think that's a great tool here to address the real problems that are giving people pain.
Well, because, I mean, going back to your earlier comment, I mean, it seems like there's not a profit motive to go after the real fraudsters or the ones that are causing the real pain because they're either offshore or otherwise committing criminal acts or what have you. That, I mean, at the end of the day, they don't make an attractive private lawsuit sort of target, at least the way I have always kind of envisioned how the litigation proceeds.
I think that's fair. One thing that we're also seeing, and we're involved in some of these, I have a couple of partners who've been deeply involved in some of the industry traceback work. Mm-hmm. We are seeing major U.S. companies now fighting back against the bad guys because, if you look at the fraud that is perpetrated sometimes or attempted, it's often using the names and identities of major trusted U.S. companies. And so they are likewise victims here. And so you're seeing big companies bring their own litigation to try and stop this at its source because they don't want customers misled by calls that are falsely purporting to be from their company.
Yeah. Well, I mean, just to give you a prime example of that, I mean, just earlier this week, I've been getting calls that have shown up on my caller ID at home with a major bank with whom I personally do business, and pick it up, and then it's somebody trying to sell me solar panels. And somehow I don't think they're trying to sell me solar panels. I think so. But
that's right, Matt.
So I mean, I do understand the frustration and the problem that consumers are experiencing under this, and also understand the pressure that policymakers are under to try to deal with it. But it seems like what they're trying to do, I mean, almost strikes me as trying to put a square peg in a round hole with what they're trying to accomplish, at least at the state level. So.
Yeah, I mean, I think if you accept the premise of what you said earlier, that the true bad guys are often going to be hard to find and or judgment proof, does it make sense to then turn civil litigation on legitimate US businesses for compliance problems, mistakes, difficulties, or fact questions about whether consent was given? I just don't know that that's the right solution set if we're really talking about folks like the guys in Texas who put out over 1 billion illegal robocalls in a span of time. That's not the same thing as the defendants we see in the TCPA litigation to date.
Okay. Well, Megan, thank you for joining us again today. I know this is, unfortunately, this seems to be a perennial issue for the business community, and it's definitely a litigation issue that's kind of the gift that keeps on giving, unfortunately. But thank you for joining us, and I'm sure this is not going to be the last conversation we have on the issue. And thanks to all of our listeners and viewers for joining us today. And this was Cause for Action. So thank you.